Hi, everybody. Sorry for the delay today. It was a little bit like the CEQA process. There were two experts at the airport, mechanics, that couldn't agree on what to put in the log for the maintenance, and we couldn't leave the airport until they did. But unlike the CEQA process, they didn't disclose to us what those issues were. So. Okay, sorry. And is there, just hit the key to advance the slide?
We have a presenter.
And you actually put the down button.
Down button. All right.
I'm going to grab my water.
Sure. If you want. It would be like a preacher.
All right. Okay. Well, I'll get right into it. And again, sorry for the delay. A little just housekeeping to start with. I'm happy to take questions as we go along, but there's a lot of people. And so if it's starting to slow the process down, I might ask you to hold off on questions to see if maybe the rest of the presentation answers those. I'm getting a little bit of a... is it echoing for you guys too? Okay. So... just a quick overview, and a few things I'm going to go through quickly. I think Sean addressed them. If I'm going through it too quickly, just ask questions if you want more information on things. The basics, CEQA is, it was modeled after the National Environmental Policy Act. It was adopted in 1970, and wanted to show some examples of things that I think are helpful. There's the CEQA, the Act, and then there's also the CEQA guidelines. And there are several books out there that I recommend people that are going to be working with CEQA a lot to get, because they'll have both the guidelines and the Act in them. And the one that I like best right now is the Association of Environmental Professionals. It has a really good index that you can use to figure out which section of CEQA is applicable to the issue that you're addressing at that point. It looks like this. We also use this book from the American Council of Engineering Companies. It's pretty good, too. It doesn't have an index anymore, though, so it's a little less helpful. So, as I'm sure you gathered from Sean's presentation, CEQA is a process, not a permit. CEQA only comes into play when there's actually some other project that's happening, and CEQA review needs to be done as part of that project. It's never done just on its own. The main purpose of CEQA is to focus on addressing adverse physical impacts to the environment. And the purpose is to avoid those impacts before it's too late, to study them before you've gone too far along and can't stop from imposing those impacts on the environment. And in addition to the protection of the environment, one of CEQA's overarching purposes is to allow for self-informed government, or informed self-government. This is the public participation aspect of CEQA. It has a great platform for the public to get involved in the process of projects that are going to have impacts on them. And it does that through these four ways, by disclosing information regarding a project to the decision makers and to the public. These are the W's, the who is proposing the project, what is the project, where is the project going, why is the project going in? Those are the project objectives. And when is the project happening? What permits are needed? What other approvals? You have to look at everything that's going to be required as part of this project moving forward. It needs to identify the significant adverse environmental impacts of the proposed activities. It seeks to prevent environmental damage by requiring either feasible alternatives or mitigation measures. And it, again, provides a great opportunity for the public to participate in those decisions. And as we discussed a little bit at the end of Sean's speech, You don't always get the result you want at the end of the CEQA process, but there are avenues to pursue after that. You can sue the agency for approving a project in violation of CEQA, or if it's a reoccurring situation with that agency of approving projects without proper CEQA review, vote them out. Cultivate another candidate for that position that understands what the CEQA process really requires. So, and can everybody see the little chart? I'm not sure if that's big enough. But this is a way of identifying all of the different participants in the CEQA process. And at the center of all of it is the lead agency. That's the agency that's approving the project, or in some instances, it's the entity that's going forward with the project. Then comes the responsible agencies. And these are agencies that are also going to have to approve a part of the project. These are agencies like the California Coastal Commission. If there's a home proposed in Santa Monica within the coastal zone, the city of Santa Monica does they're the lead agency. They're going to approve the permits needed for that home. They're going to prepare the environmental review document. But that home is probably also going to need a coastal development permit from the Coastal Commission. And the Coastal Commission can rely on the environmental review that was prepared by the lead agency when they do their approval process. There's also some projects that have a lot of different agencies involved in them. We've worked on this for several years now, a very large housing development project. It's on endangered species habitat, and it's in a creek bed, and it requires a new on-ramp to the freeway. So the city approved it, but we're now working through the process of some other agencies who are a little more sensitive to the environmental impacts of this project. The Department of Fish and Wildlife and the Federal Fish and Wildlife Department, or Fish and Wildlife Service, regarding the endangered species issues. They need to potentially issue a jeopardy finding regarding the impacts to this species. The project will also require a streambed alteration permit from the Regional Water Quality Control Board, and it will require Caltrans's approval of the freeway off-ramp. So for one, the projects can have lots of different approvals, but the CEQA document should analyze the impacts of all of the approvals that are going to be required as part of that project. There are also trustee agencies, and these are agencies that have jurisdiction over certain impacts throughout the state. This includes the California Department of Fish and Wildlife, who have jurisdiction over wildlife within the state. The State Lands Commission, who has jurisdiction over state tidelands. There's just been an issue in San Francisco on this, where the citizens of the city passed an initiative to limit heights along the shore, and the State Lands Commission has come in and said, well, no, we have exclusive jurisdiction over those areas. You can't regulate the heights, and that's in court now. The city is defending its right to have that ordinance in place. Not really a CEQA issue, but just to give you an example of the jurisdictional issues that come about. As part of the CEQA process, the lead agency is required to consult with these trustee agencies and the responsible agencies regarding the impacts that are within their purview. Also in the process is obviously the applicant. It could be a private developer, or in some instances it's the lead agency itself is also the applicant. If a school district wants to put in a new school, they both propose the project and approve the project. Yes?
Isn't there a conflict of interest that having them be both?
It seems that way sometimes. Yes, it does. But that's one of the great things about the CEQA process, because it allows for the public to participate within that process. And if they think that the self-interest of the agency in improving its own project blinded it to some of the impacts or feasible alternatives, they have the ability to go to court over those issues. the EIR preparer. The EIR can be prepared by the lead agency. Some planning departments do the preparations of the EIRs in-house. Sometimes cities or counties will hire outside consulting firms. And the applicant, a private developer, can also hire the EIR preparer for a project. And then submit that to the agency for consideration. And then the public has a strong role in this process as well by commenting on the EIRs, by suggesting alternatives, and just basically ensuring that the agency follows the law. And last but not least, there's always the option that the court could get involved with the CEQA process. Yeah?
Could you comment, because I think many people don't understand that the CEQA case relies upon the administrative record, and perhaps after the decision has been made is the worst time to get an attorney involved, because the attorney is then stuck with the administrative record that has been prepared by the public, which doesn't understand what may or may not be critical for the case once it gets to court.
I agree with you 100%, yes. Yes, certainly. Basically, your comment was that sometimes it's too late to get an attorney after a project has already been approved. Because when you bring a CEQA case, the only thing that you can rely on in bringing that case is what's called the administrative record. And the administrative record is all the documents that were submitted to the agency up until the point that project was approved. Anything submitted after that, anything that you have on a shelf in your closet that was never submitted to the agency, can't be used for support in a court case. So if you're trying to say that a project will have significant impacts on a certain species, and you have this great report, but you never submitted it to the city, it's going to make the case a lot harder for you. Or if you have something prepared after the project's been approved, it's not going to do you much good. And so hiring an attorney earlier in the process, at least consulting with an attorney who can make suggestions on areas that perhaps you can comment on and information that you should get into the record can be really important to build that record so you have a strong case going into litigation. Yeah?
So up to the point where the project is approved, that means you can submit documents up until that final hearing board of supervisors? Or
Generally, yes. There is one case that's kind of an outlier that says that, for example, if the Planning Commission has the ability to make a final approval of the project, and the only way to get that up to the Board of Supervisors is to appeal it up to the Board of Supervisors. The Board of Supervisors has the ability to cut that time frame off earlier because of the way CEQA is worded. It says up until the approval hearing, and so if the Planning Commission is approving it, that's considered the approval hearing, and the hearing before the Board of Supervisors would be the appeal hearing. That's it's kind of an outlier, but it is important to get that information in as soon in the process as possible.
do they have to notify you of that date in advance, or can they say that today is the day you're done?
There should be notification of any public hearing on a project.
This hypothetical deadline prior to the board of supervisors.
Yes, in the case I'm talking about, there was a city-county ordinance that said the Board of Supervisors will only consider materials submitted 5 days prior to the Board of Supervisors hearing or earlier. And so there was an ordinance that said that. Not everybody's going to dig through county ordinances. So again, sometimes it's helpful to have an attorney advise you on those types of things, but also to generally familiarize yourself with the land use procedures and hearing procedures for the agency that you're working with. Did everybody get as a handout? Yeah.
Just in addition to that, in Napa County, our Board of Supervisors has a choice to hear it on the administrative record or have a hearing de novo. But they require that you submit evidence as to why that additional information could not be heard prior to the.
I'm sorry. they'll only use what's already in the record.
The supervisors can choose, and Brad is here, he can clarify, but they can choose to have an appeal hearing either on the administrative record or hold the appeal hearing as a hearing de novo and allow new evidence and hear it over again.
I'm not familiar with how exactly that works, but any hearing on it should be de novo. They're reconsidering the facts and new CEQA determination. And one more thing on the exhaustion issue, and I'll kind of get to this later, but while we're talking about it, if, for instance, a planning commission approves a project and that's a final approval unless you appeal it, in order to bring litigation, you have to have appealed that planning commission's decision up to the Board of Supervisors or the City Council.
I have one very quick one, that in some cases you don't want to divulge the information too quickly and make it part of the public record if you're opposing a project, because it gives the applicant a chance to respond more vigorously. Rather, anyway, that's something that we run into, is that you kind of want to time your information flow, but definitely get everything in before.
Right. If there's a comment period on an environmental review document, that's a good time to get that information in. The day of the hearing, it's not going to get consideration by the approving body, and courts don't look favorably upon that. They call it last-minute document dumps. But if you have some special information, maybe you want to strategically get it into the record at a certain time, that's the consideration. But in general, if you have evidence of a significant impact, you should submit it as soon as you have that, so that if the CEQA process is working properly, they can find ways to mitigate that impact.
Are you going to be talking today about the potential changes at the state legislature that would affect court cases, CEQA court cases?
I can talk about that later today. I think I have a copy of some notes on I brought that with me on some things that have been proposed. There hasn't been as much activity in the legislature on CEQA this year as there have been in previous years. Did everybody? Oops. Oh. No. How do you go back? There we go. Okay. Did everybody get a copy of the CEQA process flow chart? No. Okay, well, even if you didn't, this is something that you can get this on the, let me give you the website right now.
You can get it on OHP's website also.
Okay, you can get it on OHP's website and, at resources.ca.gov /CEQA/flowchart. And I found this chart is very helpful to use to go through the CEQA process. It kind of, it's a choose your own adventure of what type of review a project's going to get. It asks questions, and depending on the answer, you go to a different part of the chart. So, to begin with, the determination is whether you have a decision to approve a discretionary project. And there's a couple of questions that come up when you ask that question. CEQA applies to the approval of a discretionary project. Well, first, what is a project? A project means any activity which may cause either direct physical change in the environment or reasonably foreseeable indirect physical change in the environment. So it's probably more helpful if I give a couple examples of things that aren't projects. For example, if there's a county ordinance to increase sales tax and there isn't anything that increased revenue is designated to fund, that's not something that would have a direct physical impact on the environment. And the the indirect physical changes would be very, very far removed. It would be speculative if there'd be any indirect impacts from it. So that would not be considered a project. There was a case maybe 6 or 7 years ago in San Francisco called the Martin case. And in that case, there was a historic home where someone applied for a permit, the owner of the home applied for a permit to make some changes to the interior of the home. And this was a home that everybody agreed was a historic resource. Everybody agreed pretty much that the changes that were being made they could have an impact to that historic resource. But the court found that this wasn't a project that could have an adverse impact on the environment because it was a private home. Nobody could see into the house. The only time you would see what had happened inside the house to that resource is if you were invited into the home. And so that's not an impact on the environment. It has to be something that can be experienced by someone other than that person applying for that project. So that no one else is going to see what was being done in there. That wasn't something that needed to be considered through CEQA review.
What about a cave?
A wine cave? If the public is being, I guess there's a couple considerations. What's being done with the alterations? Is it to expand business? Then there could be some indirect environmental impacts that come about as part of that. Are there going to be tours of those caves to the public? Maybe that's making it into an impact on the environment. And once you open it up to, let's say nobody's going in there but the people that own the cave, but it's going to have impacts outside of that cave. As part of the CEQA process, you should consider all of the impacts, the whole of the project, even if on its own, if there weren't any exterior impacts, it wouldn't require CEQA review. Once you get into CEQA, you need to study everything. There are a couple of different things that CEQA defines as projects. An activity undertaken by the public agency itself. These are things like what I described earlier, the school district approving its own new school, when a county, city adopts an update to its general plan. Those are considered projects under CEQA. When a public agency is funding someone else's project, if they're giving a grant for restoration of some wetlands or some other project like that, then it falls under a project for CEQA. And then finally, the most common type is the private development that requires some type of approval from the agency. If no approval is required from the agency, then it isn't a project. But if there's any type of permit, license, lease, any type of entitlement like that the county has to, or the county, city, whatever the entity is, has to approve, then it would be considered a project under CEQA.
If the city sold some property for affordable housing for $1, would that be considered funding a project?
It should be, yes. Actually, there's a case that somewhat dealt with that issue that my firm worked on, the Save Terra case. And in that case, the city of West Hollywood sold a historic home that had been granted to the city, donated to the city by its owner, for, I think, $1 to a housing development company that was going to put in low-income senior housing. And they approved a development agreement and said, well, once they finalize exactly what they're going to do with the senior housing, then we'll do CEQA review. And the case law said no. The California Supreme Court said, you've committed yourself to a course of action. You have said that you're selling it to them for the purpose of putting in this senior housing. And they had pretty detailed plans of what the housing was going to look like. And so CEQA review was required at that time. Is this a... I know lunch is here. I'm going to get through a couple more slides. Yeah.
If I could just expand on that a little bit. Let's say you're at point where the development corporation is already involved in doing their CEQA documentation, and you realize that the initial decision, this selling it for $1, really should also have been considered, but it's already happened.
If there are future approvals, I always argue, and I'm not familiar with any case law on this, but I always argue that you pre-committed yourself back then. You have to have an expansive alternatives analysis that considers something other than what you were pre-committing yourself to when you sold that for $1.
But there's no case law.
There's not any case law that I'm familiar with directly on point on that, but on either side, so I think it's a worthwhile argument to make. And I will say a lot of times agencies are very uncomfortable with being told they've pre-committed themselves to a project. That's something that we found they really don't want to have done.
But they just don't want to hear about it.
Well, I think there was some discussion earlier about discretionary versus ministerial projects. Discretionary requires exercise of judgment. Ministerial uses fixed objective standards. So a ministerial project would be, let's take a sign ordinance and look at it from a discretionary and ministerial. If it's ministerial, the sign ordinance would just say the sign can't be more than 50 feet tall and it can't be more than 15 feet wide, and it can't be lighted. When approving that, those are fixed standards. The agency just says, is it 50 feet tall? Yes, we approve it. No, we don't. Or less than 50 feet tall. Does it meet the 15 feet, less than 15 feet wide? And will there be lighting? So those are a ministerial type decision whether that sign should be approved. But if that sign ordinance also requires that the sign not be distracting to drivers and be aesthetically pleasing to the community, well, those are very discretionary type of terms that some type of review of the design has to be incorporated into the process, and that's not a fixed standard, so that would be a discretionary type decision. Just in anticipation of this conference, I found that most vineyards in California do require some type of discretionary review by the host county, but the county of Mendocino allows both vineyards and wineries as of right uses that are just ministerial approvals that do not require CEQA review. I thought that was interesting.
What about other crops? Maybe they decided to roll over.
Yeah.
What right do they have? What is that?
By right. Mm-hmm. We talked about this a little bit, that are already the scope of the project. If there's some aspect of the project that requires, that would be considered discretionary, the whole project needs to be reviewed under CEQA review. So if there is the demolition of a historic building and that agency doesn't have any discretion in approving a demolition permit, that would normally on its own be a ministerial approval. But if that historic building is being demolished to make way for a large shopping center, and that shopping center requires a discretionary approval from the agency, then the environmental review document needs to study the whole of the action, both the demolition and the new construction. And along the same lines, agencies are not allowed to piecemeal or segment their environmental review. If a developer is planning to build 50 homes, and he knows that the agency will approve 3 homes as ministerial, and he just applies for 3, or he or she applies for 3 at a time, but it's clear that he has a plan for those 50 homes, that's improper segmentation of the project. He should have studied all of them at one time. Yeah?
Have you involved in a situation where there's segmented
It sounds like something where those are part of the whole of the project. Some of the things that they look at are, there was a case that looked at whether it's the same applicant for both of the projects that are being separated, if their timing is similar, and whether the purpose of the two is kind of go hand in hand, if they need each other. Do they have, sometimes they say independent utility, but there are lots of things you could say have independent utility. But if they're intended to go forward together, they should be studied together.
Can a parcel map be, have a secret EIR without plans for what's going to be going on there?
There's kind of a balancing of when the CEQA process should take place, because you want it to happen as early as possible. And so in that instance, if they don't know what they're going to do yet, they might do a higher level, more generalized CEQA review document that says, we're going to tear off this later, but do more specific review once we know exactly what we're going to put in place.
So you can do an EIR on the parcel map even though you don't know what's going to go there in detail?
You could, yes.
I think that was kind of similar to my question. If somebody owns X amount of acres and they're planning to develop maybe a small portion for some sort of agricultural practice, but the overall property could potentially sustain much larger, they could piecemeal or do it in phases. They wouldn't have to show the potential.
Mm-hmm. And one of the things that's looked at is for an instance like that, whether the actions on the rest of the property are reasonably foreseeable. If you have no idea what's going to happen there in the future, you might not study that in the EIR for the first part, or you might, in the cumulative impacts analysis, to say, well, developing part of this land is going to make it easier to develop the rest of it, and so we should study, at least at a high level at this point, what could happen if all of it's developed. Okay, I thought I saw another. Okay, and then the final part of this, so CEQA applies to the approval of a discretionary project. So we talked about the difference between discretionary and ministerial. We talked about what is a project. The final part of this is what is project approval. And this is the case that I was referencing earlier. And that's actually a picture of the home, which the owner had referred to as Tara because Gone with the Wind was her favorite movie. And in this, the California Supreme Court did find that the city of West Hollywood had pre-committed itself to a certain project before doing CEQA review when it approved a development agreement that had some fairly detailed plans for what was intended to go in on that site. And what was planned for this site was to demolish the historic carriage house and take out a lot of the trees that you can kind of see in this photo, and add in more senior housing, which obviously that's a great benefit to the community. But our clients had suggested other locations that might be better suited to that type of housing when there's a limited amount of green space within cities. I'm happy to report that as a consequence of our lawsuit, this site has been preserved as a park, and the buildings are used by a nonprofit, I believe, at this point. So sometimes CEQA litigation just gets you a new process, but sometimes it does actually help change the project that had been proposed. So next part is going into whether a project is exempt, but this seems like it might be a good point to since we kind of wrapped up what is the approval of a discretionary project, did you? Oh, okay, I thought I saw a hand. It might be a good time to break for lunch. And we can come back and talk about exemptions and the rest of the CEQA process.
A little bit of housekeeping.
Okay.